Hello, everybody, and welcome to our Sullivan on Comp presentation number 16 on the COVID stuff. Today, we're talking about Senate Bill 1159, which is the long-awaited presumption bill that has finally passed the legislature and is sitting on the governor's desk. And we're going to talk about it in some depth. It's kind of complicated, actually. There's a lot of different moving parts, and so I have brought in some help. And what stands before you is the lovely and talented Adam Dombchik of GEK Law. Hello, Adam.
I've been beckoned and I'm reporting for duty. Thank you again for having me.
Yeah, you know, Adam and I have done a lot of these presentations together. How many of all the COVID ones did you do with me, Adam? Was it like 3 or something?
3 or 4, yeah.
Yeah.
Those were definitely the best, I hear. Is that true?
I can neither confirm or deny. So that's our picture. That's me on the left. I'm Mike Sullivan, and by way of background for me and Adam, just briefly, I run a law firm, Michael Sullivan and Associates LLP. It's a statewide firm with 9 offices throughout the state, and we have a lot of different sections. But the heavy lifting is workers' comp and employment law. So that's me in my daily life running this firm. But I'm also the author of Sullivan on Comp, and that's a comprehensive legal treatise. If you're listening to this, I'm sure you know what it is. You're probably a subscriber. Although I think we're making this available to the world at large, the COVID presentations, just because it's so important. But you know, it's a treatise that covers all of workers' comp law in California. Adam, you use it, right?
Every day.
Yeah, that's what I like to hear. And it's got a bunch of tools. It's really cool. And when I do a Sullivan on Comp lecture, I try to take off my my defense attorney hat and put on my neutral hat, because we like to discuss all aspects of all issues and get all the different arguments that will be made by all the different sides. But with Adam here, I think what's going to end up happening is I'm going to end up playing defense attorneys, because Adam is such a liberal communist pinko. Right, Adam?
I can't hear you. There's a banana in my ear.
Yeah. Okay. We're gonna have to do better on humor, Adam, or I'm gonna have to boot you out of the presentation. All right. So tell me about your firm a little bit.
We've been around for about 30 years. Our primary focus is applicants' workers' compensation. That is all that we do. We do no employer side work, and we're fortunate enough to be in a position to represent injured workers throughout just about every county in Southern California and beyond. So that's a little bit about us.
Yeah. So, you know, look, I mean, a lot of applicants attorneys out there I don't respect, and a lot I do. Adam's one of the ones that I do. And over the years, you know, he and I have had some hard fought battles, but over the years, I think there's been some respect, at least for me, to Adam. And we've been able to collaborate on a lot of different educational events throughout the year. And it's good to get both sides, I think. So that's what we're going to do. Also, I just wanted to briefly mention the different COVID web series we've done so far. You know, when COVID hit, we decided to try and lead the industry. We had Sullivan on Comp, and we wrote a book about COVID. I'll tell you more about that in a second, but we did a whole bunch of presentations. So they're available to you. If you're a Sullivan on Comp subscriber, you can get credit for it. If not, you can go to the Michael Sullivan and Associates website, and you can listen to these things for free. Although I don't think you get credit for it on that site. But anyway, these are the subjects that we did. We did some stuff with our employment law attorney, lead attorney, Eric DeWames, and we talked about the interactive process, reasonable accommodation, all the different federal rules and provisions that were made for this special time. And then we went through the issues: when to provide a claim form, when liability for TD, when is it work related, when is it not work related, when is it affecting underlying conditions. And then part 8 was Governor Newsom's executive order, which we're going to talk about again today, because part of the legislation was enacting the order for a limited time period. And then we did psych injuries. You know, you get sent home and you're stressed out. And, you know, I won't read them all to you, but we did all the different topics that we could think of in the COVID webinar series. And we stopped doing them because I ran out of things to say, and I didn't want to talk just to hear myself talk. I thought 15 might be enough, but evidently it's not, because we're back for section 16. You all should be aware that there's a book that we wrote, and it's cool. It's always up to date, and it answers every question, deals with every topic about COVID for immigration, employment, and workers' comp law. It's really complete. If you printed it out, it'd be about 200 pages. We update it on a daily basis, and it's really, really cool. So we have, I think last I looked, there's about 1,500 people a week looking at this book. It's live, it's online, it's not printed. and it's always changing as the law changes. So I hope you take a look at it and you find it useful in your life. And I just want to make sure people were aware of it before we jumped into this. Also, I was asked to talk a little bit about IEA. We're working closely with IEA these days, the Insurance Education Association. And we're trying to redo a lot of the courses and make it better and add new courses, and we're really excited to be working with them. But here's the list of things that we're doing right now. We have the Intro to Workers' Comp claims. These are all for claims adjusters. The new adjuster training, which turns a regular person into a workers' comp adjuster, 120 hours worth of training, WCCA, WCCP, rating instructions, and prep for the self-insurance exam. And finally, the Certified Professional in Disability Management. So these are all the courses that are out in the fall. We'll keep you up to date as we work with IEA to create a more robust and iterative set of courses for the claims industry. Okay. Adam, do you have any COVID claims?
A handful. Some in my own caseload and some being represented by other members of the firm. When we started this conversation a few months back, Mike, I raised some question as to concerns about the number of claims that we might see from a litigated legal perspective. And at least on my end, I think so far that the claims, I'd say two things. One, they kind of range the gambit. People that call are better back to work after 14 to 21 days, don't seem to have too much in the way of residual issues, have been cleared to go back to work, and they're functioning pretty well. Then there are some that either had some underlying pre-existing issues that have been aggravated and it's unclear what the future holds for them. And then ranging all the way to death. The volume, I don't believe, has been substantial compared to the other calls that we get on say, a monthly basis. And I think as a firm, we have given advice, and I'll talk a little bit about that advice as we get to some of the statute, because I think it's relevant, but I still.
Adam, I can't hear you. Adam, I can't hear you.
Well, and hoping that they don't have any recurrence of issues.
You just cut out for about 20 seconons.
I apologize.
Yeah.
I think, you know what, because I'm looking at you and every time I turn my head.
No. You went totally silent. You were like, your microphone wasn't working or something.
Sorry about that. Let me just restate it then briefly. Is that okay?
Yeah.
Great. Firm-wide, we have a handful of cases. I do not think the volume is substantial compared to the other normal inquiries that we're getting.
Okay.
And they range the gamut from people calling that just need information to make sure they're protected just in case, but they're better and back to work, through people that have had underlying conditions that have been aggravated or they have residuals from the exposure, to a handful of death cases. But by sheer volume, it is not a substantial amount of inquiries so far.
Yeah, I'm interested in the cases you referred to where, and Adam, I don't think it was I think you must have hit a button or something, because you just went totally silent and then you went back on, but it's fine if we're fine now for your audio. But I'm interested in those cases where the people are not fully recovering or they're having residual problems, because I always assume that this would just be like a flu, and if you got better, you got better, unless you aggravate an underlying comorbidity. So what are you seeing in this regard, and how frequently are you seeing it?
I think the common complaint that I have is people still feel somewhat fatigued. They still have some residual loss of sense of taste or smell. And some of them feel some shortness of breath. Those seem to be sort of the top three residual symptoms that I'm hearing. And the physicians that these workers are seeing, some of them are saying, you're fine, go back to work, I don't need to see you again. Others are having them come back in for updated evaluations down the road. I think if those symptoms persist, depending on what we continue to learn about the medicine of this illness, they'll probably do some updated testing and see if there's been any permanent scarring in the lungs or any other permanent, objective residuals that could explain those ongoing symptoms. That's kind of what we're seeing.
What about psych? I mean, aren't you guys going to add psych so you can make some money on these cases where people get better?
If I have 10 COVID cases, I think 2 of them have a psychiatric component.
Okay.
And in both of those instances, by the time the people came to see me, they had already sought out the psychiatric care. So it was
Okay.
not something that Adam Dombchik manufactured. It's something that grew organically, unfortunately. That's about what I see at the moment. Certainly people that were on respirators, people that seem to be having long-term effects, it's a legitimate conversation for us to have because they're certainly entitled to that type of care.
Yeah. Okay. Well, I mean, I think you're the type of firm that doesn't have unreasonable exaggerations of body parts typically, but it's not necessarily how everyone in the industry operates. So you'll understand my little teasing cynicism there.
Fair enough. I get it.
Yeah. Yeah, we got some too. We got a few dozen in the office. And what we did is we set up a conference call every month just for everyone with cases. And we just talk over issues and fact patterns and strategies. We've seen a relatively small number of death cases. You know, I put up this page here and it's from the CWCI and it's such a cool page. If you go to their website, you can see that they have this map and they track the COVID claims in California. They keep it constantly updated. So it's really informative as to what the overall situation is in California. And I thought it might be appropriate just to dip in here just for a second to verbalize some of this. What I'm seeing now is the total claims of COVID in California made through the end of July was just under 35,000. And the deaths for the same time period are only 168, which I think is remarkable. Now, look, if you file a claim, you may be starting with the COVID process. So if you're going to die, it may be later, right? But so there's probably some lag, but still that represents 0.4% of the COVID claims made a result in death, which is less than we've been given to expect in terms of the relative statistics regarding death and COVID. But again, the jury's still out, but it seems really low compared to what we thought was going to happen. Anyway, there's also a statistic that says as of August 24th, there was 36,617, which means there's only been like 1,500 or 1,600 more deaths in August. It's slowed down. If you look at the pace of it too, it's not on this page, but on the pace of it, you'll see it on the site. There was 3,000 claims filed in March, 4,000 in April, 5,000 in May, and then it jumped to 11,000 in June. That may have been the period where people were deciding they were going to go out, right? But then in July, there was only 12,000. So it only went up 1,000 cases, or 1,000 claims in July, which is a far cry from more than doubling from May to June. So the new things they put into place after the spike in June seems to be working. It seems to be at least contained. You know, they talk about stopping the slope of infection, right? And I think that appears to be happening at least over the last month. Other statistics I thought might be of note is that of all the COVID cases, 38.4% are healthcare workers. Like a third plus are all healthcare workers. I guess it's not a big surprise, right? Because these are the people putting themselves in harm's way. And then 15.8% are public safety. So you put them together, you get like half the people are either public safety or healthcare workers. And that's the statistics as it stands now. I guess it's not a big surprise, but it does give some rationale to what we ended up here with in terms of a presumption. So what we're going to do today is we're going to talk about the Senate bill and the presumption that applies. And there's actually 3 different ways that you can have a presumption under the Senate bill, which we'll get into. We're going to talk about each of the presumptions in turn, how it applies, how it works. And then we're going to talk about the new reporting requirements under the last way you can do a presumption, which is kind of a topic in and of itself because there's a burden on TPAs and carriers. And all along the way, we'll talk about what it means in practice. So Adam, I know you have a lot of thoughts, so please feel free to spontaneously express them as I walk people through the new law. Okay?
Shall do. And there is certainly a lot with the new law.
Yeah, just come out of your shell. That's all I'm saying. So we have been waiting for this for a long time. We've been waiting for this for a long time. We want a presumption. We had the governor come out and give an emergency non-legislative presumption, like an executive order, right? Months ago, and that came out. And we've been watching them fight over this. And I guess there's two things that they say you don't want to watch happen: making sausage and making laws, right? Yeah, it's kind of ugly and it's complicated and it seems unnecessarily so. Actually, I mean, we're going to look at it, but from a defense perspective, it doesn't seem too bad. I mean, relative to what we're given to possibly expect.
I think that's a fair assessment of it. Although I will highlight some parts that I find to be rather burdensome for claims, employers, and the defense side. Maybe
Yeah.
it's a necessary part of the compromise, and we'll see how it works in practice.
Right. Now, I want to emphasize that as of this talking, it's not passed yet. Governor Newsom has until September 30th to sign or veto the bill. But there's every expectation that he will sign it. It's the only bill that made it out of the legislative session out of 3 different bills. And the other 2 were much more to Adam's liking, I'm sure. Applicants' attorneys wanted a conclusive presumption, but none of these presumptions are conclusive. They're all rebuttable. They wanted it for all essential workers, but none of these bills covers the spectrum of essential workers. And you probably wanted it for everybody that had COVID because there's such a commie, pinko leftist. But they didn't even come close to that. It's actually a fairly limited set of presumptions and people that would fall within the presumptions. So relative to what could have been, I would say.
Yeah, I would add, it still remains seen whether the governor will call for a legislative session, special legislative session sometime this fall to deal with other COVID-related legislation. So he could choose to not sign this, even though I understand that his office engaged in the creation of it. He could choose to take it back to the legislature later this fall. I think the chances of that are slim, as you indicated, Mike. But this could be a start, and they could not be done come later this fall. So we'll have to see.
It could happen, but I'd be very surprised if anything happened other than the governor signed this and forgot about it. So, I mean, we want to get it in front of everyone as fast as we can so that everyone can start preparing for what they're going to need to do to deal with this bill. Like you said, Adam, there's some burden on the claims and employers' shops, and it's going to be a pain in the neck. So we're going to need to understand this and get ready for it and put in the forms and procedures and all the things we need to do in order to make sure we're compliant. But let me just sum it up briefly. There's 3 different labor codes, okay? They're all 3212, one's 0.86, one's 0.87, one's 0.88. I think we have a typo here. But anyway, the first one just codifies Governor Newsom's executive order. We'll go over that, but we're all kind of familiar with it. It was all the way through July 6th, I think it was, and it just codifies just about exactly what he said. So that's kind of interesting because every time now we go to court and someone says there's a presumption, I raise the constitutional issue of whether Governor Newsom had violated the Constitution and usurped the legislative powers in creating this executive order, which was in effect legislation. And maybe that would work, maybe it wouldn't. But now it's codified by the legislature, voted in by the legislature. So I think the issue is kind of going away.
I think it's gone.
You think it's gone? Yeah.
I think it's gone.
I won't say that for sure, but I mean, yeah. I mean, I think it is. It probably is. Yeah. So there's that, and so there's that. So that's ensconced in the law. And then they have, after July 6th, 2 different paths to presumption. One is for frontline workers, specifically firefighters, cops, and healthline providers, home care workers. There's a special presumption for them. And if you're in that class, then you can get that presumption if you meet the specifications for it. And then there's a presumption for everybody else that's not working at home. And it's only if there's an outbreak at the place of work, right? So if there's an outbreak at the place of work, a presumption applies. So what's an outbreak? And we'll go through it in depth, but fundamentally it's 4% of the people get COVID that work there. 4% of the more of the people get COVID that work there. There's an outbreak, and the rest of the people that get it there get a presumption. And that's the basic structure, Governor Newsom before July 6th, and after that, presumption for frontliners, and then an outbreak presumption for everybody else. And that's what they came up with in the legislature. So let's go through it. it's a little complicated because there's different details, both in terms of how you get the presumption and the consequences of the presumption for each one. What's really tough is defining when there's an outbreak. So there's all these reporting requirements now. Employers need to tell carriers and TPAs when there's someone to test positive for COVID, and then the carriers have to keep track of all the specific information and decide if there's an outbreak or not, right? And if there's an outbreak, then the presumption applies, but it requires reporting and tracking information and making judgments by the employers and the TPAs.
Just two general points here, Mike. One, just a reminder, an injured employee can still prove AWCOE without having to assert the presumption, right? So maybe more challenging, but this isn't the only way to prove that you had a COVID exposure at work. And secondly, although January 1st, 2023 feels like a long time away, it's possible that these cases can be litigated over a period of time. And if you're going to litigate a presumption, unless it's extended, you better get it done before the statute is gone. A repeal is, it doesn't exist, right?
Yeah,
So
I was noticing that too. It's repealed as of January 1st, 2023. So here you are, you don't have a final order in the middle of trial, but before the end of 2022. Well, this is repealed, and we've been through this, Adam, in various legislative reforms, right? When they repeal a statute, it means it's gone. It didn't exist. We saw this with
Folk rehab is the most recent, I think, one of the biggest, most recent ones, right?
I was actually on that case, the Wiener case, and that was our case.
Yeah, that was my partner's case. Let's not go there. Boy, am I sorry I brought that up.
It was great because they repealed VRMA, and then all these people had, unless you had a final order, even if you had years, hundreds of thousands worth of VRMA owed to you, it disappeared. And that's what that case did for. So I think that as of 1/1/23, if you don't have it done, Adam, if you don't have a final order, if you're on recon, if you're on a court of appeal, you lose that presumption.
Absolutely. And that's not to say that there couldn't be legislation to extend it or to amend it. We'll just have to see how it all plays out. It feels like it's a long time away, but with the uncertainty of this virus, it's not that far away.
It isn't. And I'll tell you something else. What would be really interesting is if it all got repealed and what we were left with was the governor's emergency order, so we could object to the constitutionality of the order. Yeah, that would be a weird one. Yeah. There's also a required study, which we mentioned. It's not really important for our discussion in terms of practice, but they've required a study on the impacts of COVID-19 and new presumptions. They just can't pass a law without ordering a study these days. Can't do it. No, there's got to be a study.
Like that appeal, that alleviates somebody's concerns somewhere along the way, I guess. Makes it a softer blow. I don't know.
Yeah. So I have a few slides here on the purpose of SB 1159. This is comments that were made by the legislature as they went along in order to define what it is they're trying to do. And that's going to be important because when we're trying to interpret the gray areas here, we'll look back to what the legislature was saying about what they were trying to do and why they were trying to do it in order to make heads or tails of it. They acknowledge, first of all, that normally the rule is that unless a person's at higher risk than the general public, that infectious diseases are considered work-related. And we talked about that way back in our first webinars. That is the standard, and has been the standard for a long time. So viruses like flus and cold generally can be considered non-occupational diseases, and they're not compensable because you can't tell how someone got it. The only way you can prove it, and we had a couple of cases going back to the Spanish flu in 1918 when workers' comp was 1 year old in California. A couple of those, and another one in 1920, where the Supreme Court of California spoke to situations where people were at a higher risk relative to the general public, and the Spanish flu was found to be compensable. So, I mean, this area of law has remained dormant for a century, and now it's back, baby. It's back because we have a pandemic, and we've talked about in various webinars in depth about how it might be considered work-related. But I have a quote here in the legislative history. It says, as a result of the governor's shelter-in order, anyone who was not an essential employee was by definition not exposed more than the general population, right? The people that stayed home, they are the general population, right? So they're not necessarily at risk, but of course everyone got sent home to work. So what does that mean? Anyway, it says, and any essential employee was exposed more than the general population. because these employees are out in the community due to work. And this is interesting. It says here, the purpose of the bill is to provide presumptive workers' comp benefits to those who are subjectively infected at work who may have just difficulty proving it. What's interesting to me here is that the legislature is saying, hey, we're all about the essential employees. But as we'll see, the essential employees are not picked out as a category in any of the three routes to presumption. That's not the standard. It's either in the governor's order, it was just people that didn't work at home, some of whom are essential. Some people at home are essential, right? But it's either cops, firefighters, and healthcare, but that's not all the essential workers for the second one. And for the third one, it doesn't regard essential workers at all. So despite the fact that the legislature is saying, hey, we're all about the essential workers, it's not what they came up with. They did say that, look, the burden of fighting the disease has fallen disproportionately on a group of workers in the private and public sectors. They're right. We just saw the statistics. Half of it is on cops, firefighters, and healthcare workers. But they also mentioned people that keep the lights on, water running, food stocked, treat or ill and injured. They don't get any attention. I was looking at a bulletin from CA today talking about the migrant workers, often undocumented, that are in crowded conditions on buses and have a disproportionate amount of contracting COVID, right? There's nothing that protects this kind of worker in any particular way in any of this legislation, which I thought was interesting. I don't know what's going on with you liberals over there, Adam, but I thought you guys were trying to take care of the poorest of the poor. What's going on?
As the bulletin said, some of these people were left on the cutting room floor with respect to this round of the legislation, and that's one of the groups that you just identified, unfortunately. And they're very important to our economy. I don't know, but it happened.
Mm-hmm. So here's more quotation. It intuitively makes sense that extending a presumption to these workers would further the cause of justice by reducing barriers to compensation system and getting them benefits. So they say they're all about the injured workers, the essential workers, but they've left a lot of them out.
You know, what's interesting, Mike, is as we go through this, I don't think they could have written the same bill in March or April. I don't think we knew enough about the testing. The testing wasn't really available. We're still learning about PPE. As it's written today, I'm not sure how applicable it's going to be come the fall if there's an outbreak or 6 months from now. This feels like a sort of evolving story without an end in sight. So today's like a picture in time, and here we go into the meat of the bill.
Yeah, I guess. It's hard to see them gathering the political will and effort to pass another modified or extended bill, but you never know. I guess it just depends on how bad it gets. But this is what we got now, and what's certainly, I think, almost certainly going to be signed by the governor. So why don't we just go through it one at a time? We had a whole webinar that went for an hour that I did a long time ago when the governor first issued the order, but I'm going to go over the terms of it here with Adam so that he can criticize me and give his 2 cents, and also just so we have a full exposition of what the law is now. So the governor's order was actually the second order issued by the government. The first was a stay-at-home order, right? So that's when we all had to go home. Like we had 2 days and we had to all go home and get our computers set up and everything. Remember that. And then he gave another order on May 6, 2020, which was the executive order that called for a presumption. And it was a rebuttable presumption, and it had standards under which you could get it. And the standards were that listed here. You had to work at the employee's place of employment at the employer's direction. Okay. Those are both 2 separate, very specific conditions which have never been really defined. And I talked about it a lot in the last webinar, but you had to be at work at the direction of the employer. You could have snuck into work when you're not supposed to be there, right? Between March 19th and July 5th. You had to be at work during that time period. And then the second condition was that you got tested positive or were diagnosed with the COVID-19 within 14 days after you're at work. Because the incubation period is max 14 days, right? So if you were at work on March 5th and then March 20th, you were diagnosed or tested positive, then no good, no presumption for you, right? Okay. And then the last is that the place of employment was not the employee's residence, which was a huge one. We had a whole webinar on home as a second workplace. And that has become the reality for so many of us, right? But it has specifically excluded people that worked at home, which we're going to see again in some of the other presumption patterns that have been produced by the legislature. But that was it. So as long as you're working within that time period at work and you got diagnosed or tested positive within 14 days and you're at the employer's direction, then you got the presumption. But there's a lot more to it than just that, of course. If it was a diagnosis, then you had to go follow up and get a test within 30 days and confirm it. Otherwise, you didn't get the presumption. And the original language talked about the testing having to be done by a licensed physician and surgeon, but this bill changed it to include a physician assistant or a nurse practitioner acting under the supervision of a physician. So obviously, that original language was too constricted, and because people are not taking a break from surgery to do COVID tests, right? So I think they deliberately changed it for the bill here. So that's changed. And so that confirmation has to be made. It also includes language here, and this is important because it's worthy of discussion relative to the other ways to get a presumption. They said you can rebut it by other evidence without limitation. So it's a rebuttable presumption, and there's no restriction on the evidence that could be used to rebut it. I find that language without limitation really interesting. If someone were to raise like an evidentiary objection to something I want to put into court, right? I would say this supersedes the judge's discretion. You have to let in all my evidence, all my crappy evidence.
I think you could expect the judge to let it in and then give it the weight that it does or does not deserve.
Yeah, they always do that to me.
Exactly. But it'll be safe than sorry.
And then another feature of this, and this is going to be, you're going to see this in the next two presumptions too, although that's not the same exact time period, but instead of a 90-day denial period, there's a 30-day denial period, which is crazy. We've never seen anything like this in workers' comp in California. You have 30 days after the claim form is filed. Otherwise, it's presumed compensable and rebuttable only by evidence discovered subsequent to the 30-day period. Now, there's a lot of different points to be made here because I just find a dearth of understanding in industry regarding a few points that I think are important, both for the 90-day rule and now the 30-day rule. How it's going to work is exactly the same. The language in the statute is exactly the same as 5402, okay? But it doesn't always work exactly as it reads. For example, a lot of people think that it is the employer's date of knowledge that starts the 90 days or the 30 days ticking. When the employer has knowledge of injury, that's inaccurate. What's actually accurate is after the date the claim form is filed, right? And it says so specifically in the language in the statute. So that's something that a lot of people don't have straight in their heads. I interview lawyers all the time, and a lot of them don't get this right. They think it's employer knowledge, and I just kind of don't want to hire them, right? And another point is that it's presumed compensable, right? But so what? I mean, let's face it, as a defense, we go to court, there's a presumption against us anyway, just as a matter of culture. I mean, it's a benefits administration system, So what's the big deal if there's a presumption against us? Well, the big deal is the teeth is the evidence restriction. You can't use any evidence it says evidence discovered subsequent to the 30-day period, but that's been interpreted by case law, and it's certain that it means any evidence that reasonably could have been obtained within the first 90 days or reasonably could have been obtained within the first 30 days. And that's why I go to court with Adam with a late denial. And I say, well, Adam, I don't care about the presumption. He says, yeah, but you can't use any of your evidence on the AOE issue because it all could have been discovered in the first 30 days. The witness statements, witnesses are out, the depot's out, any medical reports that could have been obtained are out. What's interesting about the 30-day period is it's a lot shorter. Arguably, you can't get a QME within the 30-day period. So you would be able to use your QME report as long as you acted with alacrity at the beginning of the case. You could maybe use that and say, I couldn't have easily discovered it in the first 90 days. You might even be able to say something about witnesses. Let's say you set depots of the family or the coworkers and they don't show up or you can't serve them with a subpoena. You could very well make the argument that you could not have reasonably discovered it within the first 30-day period. So in some ways, this works against the applicant. it gives us more of an argument as the defense to say we couldn't have discovered it within the first 30 days. But what's absolutely vital is that the defense act with alacrity, like not just diligence, but you're on it from day one, because your diligence is going to be what allows you to establish you could not have reasonably discovered it in the first 30 days. And in most of the cases, you'll do tracing, you'll interview witnesses, and you'll get what you think is going on, and you'll decide to deny or accept up front. I mean, I think it can't be done in 30 days. It's about witnesses, who had COVID when, more than records necessarily or depots, but records and depots are going to be part of it. QME is kind of, well, what's QME going to tell you on A? We see it, we either have it or you don't, right? So maybe more with nature and extent. But anyway, this 30 days thing is far out, and it has a lot of implications for practice.
Well, yeah, I mean, I feel like one of the best things I can do for somebody who calls me and isn't sure what to do, and they've been diagnosed and they've gotten their 2 weeks of money from the CARES Act, their salary, or maybe they work for a public entity who came up with their own plan to take care of people for a few weeks with respect to income. But I've had a couple, well, I insist that people file a claim form to protect the record, to start the process. That is just a really, really big deal. And in a perfect world, I could trust that every employer would be diligent and prompt when they have some semblance of knowledge or concern that there's been an exposure. But I've fielded a handful of calls, including one last week, a gentleman who worked for a very, very large business entity that had lots of small shops, so to speak, with respect to the employer. And his direct supervisor knew he was diagnosed, knew he was out of work for over 2 weeks because of COVID, and basically said, hey, you got paid for 2 weeks, just come back to work. Let's not make a big deal about it. Didn't offer him the claim form. This is someone who was met every other requirement of not just the executive order, but the statute with respect to being at the place of business for 14 days. So we're going to have those cases where, there's going to be a tug of war over notice sufficient enough to provide, and/or an employee asking and not getting it.
Yeah, we lost Adam a little bit there. Adam, keep on talking. We'll see if he gets you back. Anyway, what he's saying is right. I mean, it's, you're supposed to provide a claim form, and but the employer's only stopped if he does really, really, really bad stuff there. So it's the filing, I think, under almost every circumstance. Anyway, let's move on. Now, let's say you get the presumption. What do you get? Well, it has to be implemented in a certain way. Originally, they had envisioned creating an additional benefit besides the 5 workers' comp benefits, right? So there's treatment, TD, PD, death benefits, and voucher. And originally they thought, well, we're going to create a new, we're going to new benefit. We're going to give people housing, and we're going to give people equipment. And that was going to be a part of the workers' comp system, but that never survived. None of the bills that contain that language survived. So it's just the standard workers' comp benefits. There is a rule that if the applicant has sick leave benefits, and the federal government gave sick leave benefits, or some companies gave extra sick leave benefits, that those would have to be exhausted before TD was owed, so there wouldn't be duplicative payment. But interestingly, temporary disability benefits, the waiting period, the 3 days for temporary disability benefits, wait for this type of case. But Adam, I think you're back.
I am back.
Yeah. So you're waxing eloquent there, but I just had to cut you off and move on. Sorry.
That's okay. And I apologize. I didn't touch anything. I swear. The technology is great. It's this work at home thing.
Yeah, I know. That's okay. So anyway, no waiting period for TD benefits, which is unusual. I mean, not really clear why they're doing that, but I guess they are. And we'll see that it also applies, I think, in both of the other 2 instances of presumptions. TD, I mean, this was weird. And I think it applies to the next one as well, but they made this rule that TD has to be certified within 15 days of making the diagnosis in order to get TD. And that's different than the 45 days. I mean, and then if you catch it, after the start date of this period, after May 6, 2020, then it has to be 15 days after the period starts. So if you get it like before the start date of May 6th, then you got to get it within 15 days of May 6th. If you're diagnosed after May 6th, then you got to get it within 15 days from that. That is a doctor's certification of TD. And this is weird in a couple of ways. One is because it's weird because usually Adam can go back and prove TD retroactively if he wants to, right? So he can go back and say, well, he was TD during this time period, and there's nothing I can say. I gotta pay up or negotiate with EDD and pay up, right? But here they seem to be saying if you don't certify it within this 15 days, then you don't get TD. And
that might, I noticed that as well, and that might be just enough for me to not even want to assert the presumption, because that won't apply if I'm not asserting the statute. And in a lot of cases, it may not be practical to get that type of documentation on such short notice.
well, look, Adam, it only goes for 45 days total. After that, it's normal, right? So 3 cycles. So I don't think you forego a presumption or a TD. I don't think. Maybe you would, depending on the case. But I mean, it's weird. I think probably Adam or someone like him will make the argument in the future that even if the 15 days wasn't met, TD still should be paid. They'll make that argument because it doesn't specifically exclude retroactive application. But it seems to be the intent to make the applicant provide the certification, and it's a sort of a benefit to the employer as part of the overall bargain. So I don't know if that'll work or not, but I'm sure Adam will make that. I would make that argument someday if I was Adam.
To your point, it's hopefully not a substantial sum that it would, result in some meaningless litigation over the issue.
Yeah, and the person will get to EDD anyway, right? I think they can get EDD retroactively. So anyway, it's weird that this is in here, but I think it's in there just to hold people to account if they're making these claims. Anyway, so that's a feature of this one. And then I think that's all I had for that one. So we can, that's the governor's presumption. It's interesting, Adam, you and I were talking about this, is let's say you're going for a presumption. I'm going a little bit off track here, but let's say you want a presumption, right? Well, you don't know how the TD works. You don't know how the credit works. You don't know a lot of things unless you actually have the presumption. You don't know if you have 30 days to make the decision unless the presumption would apply, right? So what that says to me is that this has got to be bifurcated. If you are Adam are asking for a presumption, then you got to bifurcate it and have that trial de novo of sorts, or trial just on that bifurcated issue of whether a presumption applies in order to determine if your denial is late or to determine how the TDD is paid. I can easily see a judge decide to bifurcate these issues almost as a matter of course, but maybe not. Maybe if there's not an issue as to late denial, not an issue as to TD, then maybe you don't need to bifurcate the presumption. You can just try the whole case. But I don't know. I mean, with the evidence penalties, if there is a presumption, I would think that in just about every case, you have to try this presumption issue before you try anything else. I don't know what you think about that.
Yeah, I mean, I would think that your clients are going to have to treat every case like it's a potential presumptive case until they do the discovery, right? Yeah, because otherwise they could be, caught with not all the information that they need to defend the case if they didn't act on it promptly. One of the biggest offenses I see, not just in COVID cases, but it's super relevant to this. You highlighted earlier, Mike, that you can't get a QME in 30 days. That's impossible, right? But medical evidence is going to be necessary to assess these things. And if, 80% or more of the employers are under the guise of a medical provider network, and the regulations say within 24 hours of the claim form being received, you have to refer somebody out for an evaluation. I mean, I never see that nowadays in non-COVID cases. How are they going to make it happen so quickly in a COVID case? And who are they going to send them to who has some knowledge about the disease and is willing to see a patient?
All you need to do is send them for a test, though. You just test to see if they have COVID or not. To me, it's pretty simple. I mean, the medical side is pretty simple in terms of AOE, COE, and the presumption. You don't need to know the affecting comorbidities. You don't need to know the etiology per se. You just need to know if they have COVID or not.
who's going to take the initial history of potential exposure? It's normally the doctor, not the person administering just a test.
Sure,
So I don't
get
see
that.
why they wouldn't want to use that to get some history to help evaluate the claim. That's going to be the quickest way to get it.
Well, yeah, I mean, if it's my case and I'm dealing with an impro per and I'm a claims adjuster, I want to interview that applicant in some depth. If I got a litigated case with you, I want to cross-examine that applicant in depo. But in a litigated case, yeah, you're right. You know, you don't want the treating doctor to make that inquiry. The trouble is, I don't always trust treating doctors to make good inquiry. You know, I don't. I want to talk to myself. If I'm
Yeah, I don't know why you would say that. I mean, I trust all the MPN doctors implicitly. I don't know what
they're not. They're there to make people better. They're not there to determine whether someone's faking or not, or is entitled to a presumption. And it's like, I know how to investigate. So I know how to follow up and ask the names of other, be very specific, get the day to day, find out who the potential other witnesses are. You know,
Let me just say, what's clear as we're going through this is there isn't a single unrepresented worker that could prosecute / litigate a presumption on their own behalf. This is way too complicated. There's no way.
You're right. So it's going to end up litigated. If, you know, people, if they get sick enough, they'll litigate.
I think that's fair. And if they feel taken care of by the employer and they perceive they don't have any long-term residual issues and they got paid for 2 weeks, it's not going to be a litigated issue. And it shouldn't be probably at that point.
Yeah, it probably shouldn't be. And that's why a lot of my employers ignored my advice and provided claim forms to everyone with COVID. Just because they're like, hey, we're just going to take care of people. I'm like, what? I'm a defense attorney. I can't. But yeah, a lot of employers made that decision, and it may not have been a bad one. Anyway, let's move on. We're going to get now to the next two ways to have a presumption. And as I said, the one is for frontline workers, cops, firefighters, and healthcare workers, and one is for everybody else. So let's do the first one first. So the presumption for frontline workers is 3212.87, and the next 3 slides recite who are these frontline workers. And the statute goes in depth, right, as to who constitutes a frontline worker. And as I said, it's not all the essential workers in the state of California. Mostly they talk about firefighters, cops, and then healthcare workers. So just reading down quickly. And Adam, you can tell me if this corresponds with any of the other kinds of presumptions you see for firefighters or cops, like they use the same language.
It does. I think it's consistent in the beginning of the statute, yes.
Right. So active firefighting members, and it gives the 4 subcategories. We've seen that before.
Correct.
Right. So you'd have to just look at this and see if this person fit in. And Sullivan and Cop, of course, discusses all these categories in great depth to see where they start and where they stop. But it's down to active firefighting members of a fire department. And they serve the U.S. Department of Defense, right? And then NASA. So the same time serve NASA. I mean, who's serving NASA?
Elon Musk is serving NASA.
Oh yeah, you're right. Yeah, I love that guy. I know it's unoriginal. But anyway, and then we get down to 5 specified peace officers who are primarily engaged in active law enforcement activities. I know there's been a lot of litigation on that term. Fire and rescue services with the Office of Emergency Services, right? And then we get into healthcare, an employee who provides direct patient care, or a custodial, the janitors, custodial employee in contact with the patients. That's a distinction they're making there, who work at a health facility. So the nurses and doctors get it. The janitors get it if they're in contact with the patients. An authorized registered nurse, EMT, paramedic gets it. They don't have to be they don't have to be at a health facility, right? They don't have to provide care directly for COVID patients. Doesn't say that. An employee provides direct patient care for a home health agency under the Health and Safety Code 1727, right? So if you have a home health agency, I'm thinking that probably includes DSS. I didn't look up Safety Code 1727, but IHSS probably in there. Because it doesn't say health facilities, just direct patient care for home health agency. I don't know if that includes just people on their own or not. Employees of health facilities, if the employer cannot establish that the employee did not have contact with the health facility patient within the last 14 days. So that seems to roll it back on the janitors. And here we go. A provider of in-home supportive services when he or she provides the services outside his or her own home or residence. So maybe taking care of mom will cut it. Anyway, if you have a case, you have to go deep on this language, and it's in Sullivan Comp that describes what all these terms mean. So you should be able to figure it out.
When you just take these sections in this particular statute, this is by far the broadest group of covered employees of any presumption in the labor code. Kind of makes sense. It's a pretty broad, wide-ranging, wide-spreading pandemic, but yeah, you're exactly right. You can't top sheet this. You got to go deep on the codes. And someone, from an applicant's attorney's perspective, you don't want to commit malpractice. If someone reaches out to you and they fell under this and you didn't make the assertion and it could have cost them benefits, you've really got to pay very, very close attention to these issues.
Yep. So anyway, it's interesting here is I'm going to note this as we go along. How do you get the presumption if you are one of these essential workers, these frontline workers? Well, it's the same as for the governor's order presumption. That is, you have to perform, except it's after July 6th, right? Because remember, the governor's cuts off on July 5th. So if you're performing labor or services at the place of employment at the employer's direction on or after July 6th. So this kicks in after the governor's thing. Although I can see a case, well, let me finish this, but before I get too esoteric, you have to test positive within 14 days after working at the place of work, and it can't be at your home or residence. Same exact standard, right? Same exact standard. No home people. You have to be on site, and you got to test positive within 14 days of being on site. I could actually see that actually both presumptions apply, though, Adam. I was thinking about this. Because you could be at work both before and after July 6th and get tested positive within 14 days. So you could choose your presumption.
That is true.
How do you like that?
I like it. I think it's well thought out. I would concur.
Yeah. So the presumption, it says that if you get fired, though, it keeps going for 14 days after you get fired. So following termination of service it doesn't say why, so I guess you could quit too. But the presumption extends for 14 days after you stop working there, starting on the last day you actually work. So this actually extends past the actual period of employment. Interestingly, again, it says the presumption is rebuttable by other evidence. It's not as dramatic in its language, but it basically says you can use any evidence you want to rebut this presumption, right? Like I said, I think the other language, what was it, Adam? I was making a big deal out of it.
Without limitation?
Without limitation, yeah. We don't see that here. So evidently here, it's other evidence with limitation.
Well, assuming at the time of denial and they followed all the other rules leading up to that, and it's not excluded for that purpose.
Yeah, okay. What Adam said.
But one other point, I think, they specifically state in here, the date of injury shall be the last date the employee performed labor or services at the employee's place of employment. I think that's pretty smart language in this bill. This helps all of us that have to move these cases through the system. We have a target that we can set the date as the date of injury to debate, litigate, do discovery on. I think that's a big deal. And if you're educating an employer out there, that's really important because they're going to probably be aiding or assisting the injured worker in filling out the claim form and identifying the date of injury, more likely than not. And I think that's very clear language and really one of the smarter things I saw in the bill.
Mm-hmm. Well, it's nice that it concurs. I think all three of them actually concur. If I recall, I think the next one says the same thing.
Yes.
This one also says, interestingly enough, is that you get 30 days, again, to deny the case. So, that's the same sort of limited period that you get before. I have this, if not timely denied, the illness is presumed compensable and it's rebuttable only by evidence it could have been obtained within the 30-day period. It's the same exact step, right? If it reasonably could have been obtained in that time period, you don't get it. So it's the same analysis that I gave earlier for these kinds of injuries. 30 days. If it applies, you get the regular benefits of workers' comp again. There's no, in none of these situations is there anything like housing or benefits that aren't traditionally in the workers' comp system, as originally was hoped for by the applicants bar and the bills they proposed. So if you have sick leave, if your employer provides extra leave, just like the first one, you have to use that before you get temporary disability benefits. And if you don't get it, then the waiting period doesn't apply. So it's the same as the governor's enacted executive order. But unlike the governor's version, unlike before July 6th, there's no requirement that they certify for temporary disability every 15 days for the first 45 days. So that weird thing with TD, where you couldn't get it retroactively, you had to certify it as you went along for the first 45 days, that was not part of this. It's a little weird to me as to why they left it in for for the first one, but I guess they just said we're going to codify it and leave it alone. And then we get to the third way, which is the workplace outbreak, where you're not a cop, you're not a firefighter, you're not a healthcare worker, and you just have COVID. This is, in my mind, a surprisingly weak result for the applicant's bar. We're not even approaching anything like 4% anywhere. I mean, 4%, that's like millions of people. No, it isn't. How many people in California? Like 100 million or something? I don't know, a lot, right? Like 10 million or 13 million just in LA. So 4%, I mean, the numbers we're seeing are so far below that it's hard to see this applying anywhere. Now that's not that's only right now, and it could get a lot worse. And if it does, then this will probably kick in. And irrespective of whether or not it's realistic that this may happen, we still have to do a whole bunch of paperwork and reporting and analyzing. And we're going to talk about that. But it's really weak relative to something like a presumption, just a blanket presumption for essential workers, right? Really weak and so it's good then for the defense. It may be a catch-all if somebody doesn't fall strictly into one of the categories of public servant that we just went through 3 slides on, then they would use this one, right? Or if you are one of those field workers in a truck, right? This would be your only path to presumption. Although in that circumstance, you probably could prove it without presumption. But anyway, so this is basically establishes a presumption for those covered. It's 3212.88. It falls right after 887. And if you have an outbreak at your place of employment, and there's more than 5 employees, then you get a presumption. Now, if there's not more than 5 employees, you don't get it at all, right? Unless you fall under one of the other 2 paths to a presumption. To qualify the presumption, qualify for it, guess what it says? It says if the employee tested positive for COVID within 14 days after a day he or she performed labor or services at the place of employment of the employer's directive. Sound familiar? Adam, you're nodding your head.
Sounds familiar.
Yeah. So
the benefit today is that testing is a lot more accessible. It wasn't back then. So if someone's having symptoms, and so far the science tells us it should be manifesting itself right within 14 days of contracting it, then this shouldn't be an overly burdensome element of the law.
Yeah. Well, it does say that it can't be your home, your place of employment can't be the home of residence. So it's the same sort of structure. It says unless he or she provides home healthcare services to another individual at his/her home of residence. Right. So if you are providing home healthcare services to another individual at your home of residence, then that could be your specific place of employment. A lot of questions in my mind after reading this line. A lot of questions in my mind. Is taking care of that person have to be part of your job or not? It doesn't really say it does. It just says that if your home is your workplace, And remember, for a lot of us, home has become a second workplace, and injuries occurring at home are compensable, right? And you're taking care of someone there who's got COVID, then that's good enough for purposes of this presumption. Now, that workplace may have less than 5 employees. It's going to get hairy. You can see how it's going to get hairy, right, Adam?
Yeah, I'm a little baffled by this language. Frankly, it seems inconsistent with everything else they've done and the other 2 statutes.
Yeah. Well, I think what the idea was is they didn't want to prohibit people from claiming the presumption if there was an outbreak and they had a home workplace and someone at home was sick and they were taking care of them. But to me, that doesn't stand to reason, because it's like, if someone at home is sick, what does it got to do with you? But I mean, usually if you get injured on the employer's premises, it's work related. So since your home is a second workplace, it would be considered work related. But then you would be able to prove it without a presumption. And there's not 5 employees at that specific place of employment. So it's confusing. Anyway, the next thing they say is that the employee's positive test, for purposes of getting this presumption, the employee's positive test has to occur during a period of outbreak at his or her specific place of employment. Now, think about organizations with a whole lot of different places where people work, and think about people going from different place to place, right? So this is where they get to the specific place of employment idea. It's like where you're actually working, right? Not if you work at, FedEx or something, and, you go to different hubs, what is your specific place of employment? Well, maybe you're working in one place, maybe you're going all over the place, but they're not talking about FedEx in general. They're talking about that office of FedEx, right? Is there an outbreak there? That's where the decision is going to be made. It's like where the specific building, store, facility, or agricultural field is. That is the specific place of employment, and that's going to be looked at to see whether or not there's been an outbreak. Now, the positive test, not contracting the disease, mind you, but the positive test has to occur during a period of outbreak. So you can have a period of outbreak, catch it, then it goes below 4%, you're outside the period of outbreak, you take the test, you don't get the presumption. Yeah, so why do they do that? Well, maybe it's because, you don't know if someone has COVID until they have a test, right? And usually people get tested pretty much right away if they start getting symptoms. So this shouldn't happen too much, but it's of interest to me that you could get it during the outbreak and not get the presumption because the outbreak subsided after you were tested positive. That is possible. Or vice versa, you could get it at a point where there wasn't an outbreak, but test when there was an outbreak, and you would be entitled to presumption, even though you didn't get it during the time where there was an outbreak.
My head just started spinning on its pedestal here.
Yeah, I know, it's crazy. I think if we get these cases, you're gonna have to really pay attention to the literal language of the law and applying it directly to the case in question, because it's gonna get hairy. Like what these things mean and why they're here, it's gonna get hairy. So what is an outbreak? Well, an outbreak exists if within 14 calendar days, one of these occurs at a specific place of employment. So one of these things has to occur and you get an outbreak. So if there's 100 employees or fewer, then if at least 4 people have COVID at a given time at a specific place of employment, it's an outbreak. After that, it's 4%. If you have more than 100 employees, then you have to have at least 4% of the employees get tested positive for COVID at the specific place of employment for there to be an outbreak. And if the place of employment is ordered to close due to risk of infection with COVID by a local health department, state department, division of occupational safety or health, then that also counts as an outbreak. You don't have to meet the 4% rule if you're ordered closed. Okay, so basically that's not going to happen too much. So it says it's 4%, right? Or if it's under 100, at least 4. If it's under 5, it doesn't apply. Okay. All right. Now, what about the complications, Adam? What about the complications? Well, sometimes an employee performs work in multiple places of employment. That happens a lot in this day and age, right? You go to different, like me, I used to go to my different offices all the time on planes. And I don't know where I got it, if I got it. Well, the rule is if the employee performs in multiple places of employment within 14 days of the positive test, then it must be counted for the purpose of determining the existence of outbreak at each of those places of employment. So if you go to multiple places and you have it within 14 days, you get the testing within 14 days, then you have to look at each place of employment. If there's an outbreak at any of them, then you get the presumption.
So, what about the delivery truck drivers? People aren't going to the stores like they used to. Everything's being delivered. Is their place of employment LA County? I mean, how do you do the math in that regard?
Well,
it's not just the hub where they pick up their stuff and left. They're out in the public delivering all day.
Yeah. What's interesting about this is that, if you look at the original governor's order, it just says, it's your place of employment. It doesn't define it. And then it says, but not at home. And what people generally thought that meant was anywhere that you were asked to be by your boss, whether it's at a physical location owned by the company or out in the field, like you say. In this case, it may be a little different because they're talking about specific places of employment where people gather, right? So there's no answer to that question right now, as far as I can see. I don't see, though, how it's going to be tough, I think, for you guys to establish that the city at large is a specific place of employment, but you may very well be able to. It's simply not addressed as far as I can see by the law right now. So anyway, it says if the conditions are met, then injury, it's presumed to be arise out of employment. And it does extend to every covered person following termination for 14 days, just like the frontline workers presumption. If you stop working there, you still get it for 14 more days. Now, the presumption is disputable, right? And the language here is it may be controverted by other evidence. So it's not, what was the original one? I keep forgetting, Adam.
Without limitation.
Now, it says that it could be controverted by other evidence, but then it goes on to say, including but not limited to these two things, which means you can use any evidence, but we'd like to point out two different ways that you could do it, right? Which is weird because why not just say just other evidence? Yeah, but that's what they did. They said, well, these are two things you may use, which is included but not, as part of the other evidence, but is not the totality of the other evidence.
Clearly they thought you weren't smart enough to figure out how to rebut the presumption, so they gave you a little roadmap here, Mike. You'll have to ask your employer what they did to mitigate the potential exposure. Although I probably would have asked you that question right at the onset of the case anyways.
What in the experience of the defense bar, what would lead one to believe that not everyone knows everything?
Maybe this is, when I read this language, I thought, okay, they're encouraging employers to take measures and reduce exposure under this presumption by creating a safe work environment with all the guidance that's out there for that. And so, I don't have a problem with that language. Do I think that makes a big deal one way or the other? Probably not, because we're going to talk in a minute just how difficult it is to rebut one of these presumptions. Just the fact that they took measures won't be enough to rebut it alone. No way. No way.
Yeah. Well, it says the two things are evidence of measures in place to reduce potential transmission, glass partitions and all the other stuff we're doing at work. And then evidence of an employee's non-occupational risks of COVID-19. I mean, the only way to deal with this is to find someone in their personal life who's got COVID, if you're a defense, and then show that there's no one at work who had it, right? That's only the real way I know that so far that I've seen it's going to be effective in rebutting a presumption. But anyway, so those two things are mentioned as things you could do if you wanted to be an extra special evidence producing employer defendant. Now here's where it's just weird. Here they say it's not 90 days, it's not 30 days to deny the case, but it's 45 days to deny the case. Why did they do it? They just had to make it more complicated, didn't they? I just don't know why. I mean, maybe they figured 30 days was appropriate for frontline workers because you know who they are up front, and you can be relatively quick. And determining an outbreak's a little more complicated. They want to give a little more time, but still not have the 90 days, right? So it's 45 days to deny the case in this outbreak presumption path. 45 days. We had 90, we had 30, we have 45. The language is exactly the same. It's 45 days from the delivery of the claim form and filing the claim form, and then the evidence restrictions are the same. But it's a 45-day period. So there's that. So I guess that's what we're doing with this one. What about benefits? Well, just as with the other two, it's only the standard workers' comp benefits that you get. If you have sick leave, you have to pay that off before you get TD. The waiting period for TD doesn't apply. So it's the same as the last one and all 3 points. Credit, no waiting period, TD to be provided.
Just a reminder, the waiting period, right, is, if you're off for 3 days, you get nothing. If you're off from 4 days to 13 days, you get 3 to 13. You don't get to collect 2 weeks of TD until the 14th day. So people that are fortunate enough to be off for less than 14 days will be able to collect, right?
Yeah. Okay, so this is where we start getting into reporting and administration requirements. As you can imagine, like just what you've seen so far, it's going to get hairy. So it says that there's reporting requirements for employers. You have to report it to the claims administrator. The employer has to report to the claims administrator when it knows or reasonably should know that an employee has tested positive, not has COVID, but has tested positive for COVID. So now we got some buzzwords, right? Knows or reasonably should know. Here's the employer. They're supposed to tell the carrier, even when they don't have a workers' comp claim. Now they have a duty to tell the TPA, hey, this person has tested positive for COVID. And it's got to be made versus electronic mail or fax within 3 business days of knowledge. Now, knows or should know, knowledge. We've seen these terms before, haven't we? We're no stranger to it in the workers' comp system. Like provision of a claim form, you know or should know, but that kind of turned out under Honeywell to mean you had to know, right, to have this obligation. So this is a wide open area in my mind in terms of what the obligation is to the employer. When do you reasonably should know that someone's tested positive? Do you have a duty to follow up? I mean, I get into it more in a couple of slides, but so they have to report the following: that an employee is tested positive. You don't use their personal name or their identifying information. They just have to say someone's tested positive because that's a privacy thing. We don't tell the other employees either who it is when someone gets COVID. The date they tested positive, the date the specimen was collected, the address of the specific place of employment. And remember, if they traveled to a lot of different places, that'd be more than one, right? During the 14 days preceding the positive test. So now the employer has to track every specific location where the employee has been and report that to the TPA during the 14 days prior to the applicant testing positive. And then they also have to report the highest number of employees working in the employee's specific place of employment in the 45-day period preceding the last day the employee worked at each place. So not only do they have to tell, how does the employer have to track and report on where that employee went for the 14 days prior to the positive test, but they have to say how many people had it in every single one of these places that the employee went to within 45 days preceding each place.
Let's just play this out for a second. This is unfortunate. It really is. This is incredibly burdensome for an employer. I mean, let's think about it from a claims administration perspective, right? They're gonna say, how many times do I get a claims file and I see a letter, please send me evidence of wages earned. And then 2 years later, the employer's never produced it. You have to act within 45 days. You're going to send a questionnaire to the employer. You have an obligation under regulation 10109 to, do good faith, due diligent discovery into a claim being made. How are you going to extract this information from an employer? And a lot of employers who are just trying to figure out how to get by because they've been set back so, badly by the state of the economy and the workforce. Being ravaged by this illness. This is incredibly burdensome, not terribly effective. I just don't see how workable this is going to be for the employer and the insurance industry. This is a nightmare for you all. What are you going to do about this?
Well, the bad news is it's worse because there's also requires employees to retroactively report this information. Okay, so any employer who is aware of an employee testing positive on or after July 6th and prior to the effective date of the statute must report the required information to the claims administrator within 30 days of the effective date of this governor signing this bill. So
from my perspective, Mike, I'm sorry, from my perspective, I get the negative inference. I get the benefit. When you can't produce this information, I think I've met my obligation.
Yeah, well, maybe. For a lot of employers, that'll be simple. People are at one place. They track how many people had it. They know how many people have the test, have tested positive. They're keeping track of it already. For large organizations, I think it's going to be tougher, but it's retroactive for everybody. I mean, for the number of employees in total at a given spot, they have to report the highest number of employees at each of the employees' specific places of employment on any given workday between July 6th and the effective date. So it's every day. You have to tell us how many people were tested positive every day in that period. So it's pretty tough. I'm going to talk about how bad it is in a minute, but then the claims administrator in turn has a duty. They have to determine if the outbreak has occurred for purposes of administrating a claim. So they have to look at each location. They have to know the total number of employees each day. They have to have the total number of outbreak each day and do the math. The quote is, the claims administrator shall use the information reported under this paragraph to determine if an outbreak has occurred from July 6th to the effective date of this section for purposes of applying the presumption under the section. So they have to, quote, continually evaluate each claim to determine whether the requisite number of positive tests have occurred during the surrounding 14-day periods. So it's like they have to, there's just like 14 days before and 14 days after, right? Or maybe it's 7 each. But it has to be within 14 days. So they have to see whether there was an outbreak at any time during which the applicant may have been eligible.
So when my client tells me that they know a certain number of colleagues that fell ill and the reporting shows something different, and I ask you to produce the employer who's most knowledgeable on this, you're going to produce them, right?
No, I don't feel like it.
Yes, you will.
Oh, sure. Yeah, well, produce them for depot if you want us to. I mean, it's going to get down to this kind of stuff.
I mean, that's unfortunate. It really did not have to be this way on this issue. It didn't.
Yeah, it didn't. Well, what if we don't do it? Well, Adam, first of all, is going to try and show that we didn't keep records and therefore there should be a conclusion by the court that the presumption applies. That wouldn't necessarily work. It'll be a fight. But anyway, what they are going to do is charge us $10,000, a civil penalty by the labor commissioner if we submit false or misleading information or fails to submit the required information. They got to catch us first, but they put in here some civil penalty teeth, and the labor commissioner's authority to investigate it and to levy the penalty. There is a labor code that sets out ways to contest a civil penalty, but this is part of it.
It's so interesting here because usually with the presumptive statutes, we produce evidence that meets the burden of the presumption, and then it becomes the burden shifts to you to rebut it. Not only do I get to meet it here, but then you also have a burden to sort of help me meet it. It's really just the most oddly drafted piece of legislation with respect to presumption that I could ever envision.
Yeah.
It's burdensome. It's workable. We'll have to see how it plays out.
Yeah. Okay. So they also said that you have to have a study on it. So they commissioned the health and safety on this and say, do a study. So it'll be in effect and come out at the end of, let's see, it's supposed to be by the end of 2021, but we'll have to see. So let's spend the last few minutes and talk a little bit about what this all may mean. One point, and I've been making this point along the way, is that who's covered and who's not covered is all the essential workers, farm workers, grocery store workers, migrant workers. They only get it if there's an outbreak, right? So I think that's kind of interesting, especially given the language of the legislator that they wanted to protect essential workers. The outbreak presumption, though, applies to both essential and non-essential workers. So the division isn't clearly made in terms of essential versus non-essential really in the system, except for they carve out some of the essential workers for a special presumption. The presumptions are all rebuttable by other evidence. We saw the pattern, right? Without limitation, other evidence, and then other evidence with these two particular things. But it's all rebuttable, and it's all rebuttable by just about, as far as I can see, any evidence the defense can come up with, as long as it falls within the rubric of reasonable evidence code, compliance. So, but what's interesting is legislative history says the employer, let's see, the employer would have to prove that the employee affirmatively did not become infected on the job. And that's gonna be really tough, I think, for us as employers. Now, look, the only way I can see to do it is find someone in their family who's got it and find out that no one at work has got it. That might pull it off. But you know, we saw a case just last week. We see it all the time with these presumptions for cops and firefighters, where they've got cancer. You can't prove that it came from somewhere else, so you lose, even if it doesn't really seem like there's any basis for connecting the cancer and work, because the presumption operates in order to make that happen. That's, I think, how it's going to actually end up being, I think, between the parties. And so, because it's hard to prove a negative, I think the fight over the presumption may be the fight over the case in many of these instances.
Well, you do have one out, and that is if they do good record tracking and they don't meet the outbreak, requirement, then it won't be applicable. So in that circumstance, there may be some motivation to have accurate and reliable reporting.
Yeah. And benefits covered. Note that I talked about this along the way too. Other bills had considered reimbursement for personal protective equipment and housing, but that never got through the legislature. The benefits in workers' comp are strictly confined, and they always have been. It looks like they're going to continue to be. It's pointed out that people are quarantined and they have to stay home and they miss time from work. And the legislature said, look, this isn't an injury. Quarantine's not enough. We thought maybe there'd be benefits for people that are just quarantined and workers' comp, but there isn't. You have to get infected in order to get benefits. So that's something that got passed by. It was just debated, but didn't come to fruition for the applicants out there. And then, of course, there is the reporting requirements, which Adam has been decrying, and I can't help but agree with. It's really going to be tough on my clients. I'm thinking about the forms I'd want to create, the default letters I'd want to send to employers if I was a TPA, telling them what to do, the procedures I want to have in place. This is information off the claim, right? So who's going to administrate it? Who's going to track it? How are they going to divide up between specific places? All this has to be gone through in depth, I think, right now by all the TPAs and the employers to make sure that they're following all these rules. What about this knows or reasonably should know that the employee has tested positive for COVID-19? And when can an employer be said to reasonably should know that an employee has tested positive? Look, this goes back to when do we provide the claim form and when does the employee have knowledge that someone may have COVID and it may be work related? And we talked about that in a whole webinar that went on for a long time, and we concluded that it has to be actual knowledge. Does the same standard apply here? It's not clear. What about the provision of the claim form if they become aware of a test? What level of investigation do they have? We've talked in past webinars about OSHA and its obligation, the obligation to OSHA to investigate.
Well, Honeywell is a case. This is statute. This seems to take us a step back and broaden the language as to what the employer should have known to trigger their obligation. I see you scratching your chin in deep thought.
Yeah, the statutory language for provision of a claim form is equally as loose, but that's not how it was interpreted by the Supreme Court. If I'm not wrong, I don't really remember as I sit here, but I think 5402 says knows or should have known. But that's
interpreted, yeah.
Virtual certainty. So I think, and I know the audit unit hates that and the board hates that, but that is the law under Honeywell. So I'm not so sure that it's going to be easy to get the employer on this if the employer has a stick-to-itiveness to stick by their guns, but hopefully it won't be in that position. Notice that if there's only a diagnosis but no test, no reports required. So just having COVID, that may trigger the OSHA obligation to investigate. It may trigger the duty to investigate to provide a claim form. It doesn't trigger this. So that's a note too. Now, once it's established, then the employer's got to report it. Right, we talked about 14 days and the specific place within a 45-day period. Employers got to keep track. This means the employers have to keep track of the number of employees working at each location every day. They got to know. They got to know not just who is tested positive, but in order to do the math, they have to say how many people worked at each location every day. They have to know that, right? And they need to make new procedures to make sure they're properly counted, and they need to make sure that the employee's personal information is not disclosed unless a claim is filed. So this is a lot for employers. Every day you got to know. Luckily, we have things like payroll. I mean, there's most employers, but the ones in the middle are the toughest. You know, it's like they can't afford the payroll company, right? And payroll company, we could probably figure that out, but just report it every day automatically. But without like ADP or payroll, something, it's going to be tough. They have to also retroactively report all the positive tests, right? From July 6th to the date of bill assigned within 30 business days. So even the ones that are known. And report the highest number of employees who reported to work at each of the specific places of employment on any given workday during the period for those positive tests. How are employees to do this? How do they maintain and get this information? It's going to be a challenge, I think, for each individual employer. And then, of course, it's not easy on the claims administrators either. They have to use the information to do the math, determine if there's been an outbreak or not, and they have to do it retroactively as well. The statute doesn't explain how claims administrators have to begin administering a claim if they determine it occurred. You know, do they have to now say, okay, there's an outbreak, so that means that everyone should get a claim form who was tested positive? I don't think so. I mean, in past seminars I've talked about this. I don't think the existence of a presumption has anything to do with the obligation to provide a claim form, but there's those that disagree. And there's investigatory obligations, as I said, with OSHA. I mean, I don't think it's notice of an injury, but I know a lot of my clients have decided that since there was a presumption that might apply, they handed out claim forms. Because, you know, I think it's based on a misconception, but it might be based on considerations other than legal obligations too. But it's a whole new world. I mean, where does it, who does this at the claims office? People only do things in conjunction with claims. Now it's like you have to keep data on all your employers. Where does that go? How do you know it's accurate? What reports should you require? How should it be communicated? How do you know it's accurate? So, I mean,
you know, confounding all these requirements too is the fact that it's an urgency statute, right?
Yeah.
If this is in fact enacted and signed by the governor, it's in effect immediately. So there's not like there's a few months, you know, usually we see the governor signed a bill in September and it goes into effect the following January and there's time to kind of get your ducks in a row, but not here. It's on.
Yeah. I think if I'm a claims administrator, I'm going through this carefully. I'm contacting all the insurers with something in writing, explaining the reporting requirements and the circumstances they're required to report it, and then tell them where to dump the information. That's what I'm doing. And if I'm an employer, I'm setting up similar things. So I think, look, it's good to get this going now if you're an employer, because it's time. You have time before the governor signs it. I mean, not that much time, but you're only gonna have 30 days. So, you know, there's going to be a scramble throughout the state to deal with this decision about how to implement a presumption for non-frontline workers after July 6th. And with that, I think we're just about out of time, which is good because we're on our last slide. Sure is interesting. You know, I'll pop back up on the radar and do these webinars when I think there's content that's original enough that needs to be explained. And Adam, of course, I would love to invite you back as always, because I love you. But I'll go ahead and wrap it up here. And here's our advertisement page for us on Comp Books. If you guys aren't already subscribers, well, you should be, because even Adam is.
I can't deny that. I think I actually am in the forward, but anyways.
Yeah, I think you have a quote from you. Yeah, you did.
I can't deny it. Darn it. I'm there on paper. Best evidence rule.
Yeah. Anyway, I want to thank you, Adam, for coming on and for fleshing it out with me. It's going to be an adventure, so let's see how it plays out.
Yeah, thank you for having me. I'm sorry for the few technological glitches along the way, but that's the current state of the world. And again, wish everyone to be safe and well. And you too, Mike. Thank you again.
Yeah. All right, man. We'll wrap it up here. Thanks, folks. We'll see you on the next one.